I'm going to be suggesting that there are difficulties with the intention-based models and that our current system should remain as it is, and that there may be unintended consequences, whatever the intention is. Very generally, thinking about widening the scope of legal parentage, where does one stop? It is obviously undesirable in some circumstances. For example, in the context of assisted reproduction, when a woman gives birth to a child as a result of egg or sperm donation, and she and her spouse, for example, become the legal parents, that brings certainty to family relations and benefit to the child. But human relationships are dynamic and not fixed. People can change their minds. And as Lord Justice Thorpe said in a case from 2012, human emotions are powerful and inconstant. What the adults look forward to before undertaking the hazards of conception, birth, and the first experience of parenting may prove to be illusion or fantasy. If we allow, or indeed compel, a gamete donor to become a legal parent so that the child has 3 legal parents, that can bring difficulties. There's one example that I've seen of this in a Canadian case from a few years ago. 2 women agreed with a man that he would impregnate both of them, and the women were a couple. The intention was that he would raise the child born of one woman, and the couple would raise the child born to the other woman. This was, you will not be surprised to hear, an unregulated arrangement. However, when it came to conception, only one of the women became pregnant, and it was the woman who was due to carry the child that the man would bring up. When the child was born, the couple decided that they would keep the child. But the child saw the man a couple of days a week. Relying on the previous agreement, the man sought a declaration from the court that he was the child's parent, but not only the child's parent, but the child's sole parent. What was going on there, one wonders? Was there an element of coercion and control? Ultimately, the court made a declaration that he was a third parent because that is allowed in Canada. But in such a situation, were that to arise here, it might have been preferable for something like a child arrangements order to have been made, reflecting the reality of the situation and, of course, supporting the child's welfare. Allowing a situation where there were 3 parents like this creates the risk of conflict, of uncertainty, and of harm to the child. My second point arises from the Law Commission proposals on surrogacy, which include provision for intending parents to become the legal parents at birth. And if that involves a widening of the scope of legal parentage, the other side of that is a narrowing of the scope for the surrogate. And while there are many positive stories of intending parents and surrogates working together to create new families, and the surrogate parents and child continue to have a positive relationship, not all relationships will work out this way. If the woman withdraws her consent during the pregnancy, she will be the legal parent at birth, and the intended parents may apply for a parental order. But if she withdraws her consent after birth, the intended parents will be the legal parents, and the onus is on the surrogate to apply for a parental order to make her the legal parent. And I would argue that that is wrong. Pregnancy and birth may be a wonderful and positive experience, but they also place a woman in a unique and a uniquely vulnerable position. To require her to raise an objection at a time when she has undergone immense physical and emotional changes places an unfair burden on her and undermines her autonomy. And the burden should not be on her to withdraw her consent at this stage. The unintended consequence could be that the surrogate, knowing her role as the legal parent will be over just after it's begun, becomes concerned during her pregnancy, unhappy, unsure, and thereby withdraws her consent. And that, I would argue, risks more litigation rather than less. And while there are proposed safeguards under the new proposal, which are helpful, I would argue that it's necessary for consent to be given after birth, because people can change their minds. There was a case recently before Mrs. Justice Tice, which you will be very familiar with, X and YGA, which involved a surrogacy arrangement. And there isn't time to go into that now, but the child was born in the August. The woman began to feel vulnerable in December. So clearly, these things take time. And interestingly, there has been a survey of surrogates by Kirsty Horsey from Kent Law School. And while it is true that most surrogates thought that the intended parents should be the legal parents at birth, others were not so sure. And I would argue it's important that we listen to them. Some said, as no court proceedings have taken place, there needs to be somebody to make the decisions. That should still be able to happen. One said that this gives her the option to remain the legal guardian should she change her mind. Another said, because you created that life. And another raised postpartum depression. And even those who were undecided raised a number of reasons. And so I would argue that in these situations, there are nuances and there are difficulties, and there is no one size fits all, and that our current system is fit for purpose. There are further safeguards that can come in with agreements at the start of a pregnancy and prior to pregnancy, but that we do not need to widen the scope any further.
Thank you very much. We're now into the final stages, the penalty shootout stage, so no pressure. Andrew, over to you for the final speech in favour of the motion.